Civil law comes to us from two places. The first is what is known as a body of law. A body of law consists of the decisions handed down by judges in previous court cases. These are commonly referred to as case law. The second place we get civil law is from statutes. Governments pass laws that are intended to direct the interactions of people. Hello and welcome to the PSTN Basic Security Officer Training Series. I'm Bill Jackson. Many of the laws that are currently in the form of statutes and much of our current body of laws actually come from what is called the common law. That term means that a particular way of doing something or looking at a situation has been around for so long that people just assume that it's the way things are supposed to be handled or done. Common law is reinforced by the decisions of courts, and eventually a specific law could be passed that will deal with that particular subject. Case law is made by judges, common law comes from the common practices of people, and statutes come from legislatures. The basis of all law is the Constitution of the federal government and the constitutions of the various state governments as well. Civil law exists to handle conflicts and legal differences between individual people. The court's main function is to act as a referee. People have a tendency to assume that all law is the same and that all standards applied by law and in the courts are the same as well. Actually, there are many different kinds and branches of law, but we can easily define the two broadest categories by pointing out differences between them. Violations of the criminal law are called crimes. Violations of the civil law are called torts. The differences between the two types of law look like this. A crime is a violation against the state. All of us as citizens are the victim of a criminal act. A tort is a violation that is committed against another person. Crimes are prosecuted by an attorney representing all people and employed by the government. In a tort case, a private attorney represents the victim. In a criminal trial, the state is trying to punish the violator as an act of retribution carried out by the state. The intent is to punish the criminal and deter others from committing crimes. In a civil case, the person who has been injured is called the plaintiff. In this matter, the plaintiff is trying to regain what he lost. This is also called to be made whole again. Since we cannot turn back the clock, the best way in a free society to put something back the way it was is with money. The plaintiff is seeking damages that are intended to compensate them for their actual cost. This is called actual damages. The damages are intended to send a message to other people, to deter them from committing the same type of tort offense against someone else. This is called punitive damages. In a criminal trial, the state must prove its case against the defendant by establishing the defendant's guilt beyond a reasonable doubt. This is a pretty high standard of proof. The Constitution sets this high standard in order to ensure that the government does not file charges against someone needlessly. The government controls the police, courts, attorneys, juries, jails, and every other component of the criminal justice system. The standard is set high to protect us from the government. In a civil case, the plaintiff must prove his case against the defendant by a preponderance of the evidence. In other words, whoever has the best and the most evidence in a civil case will usually win. Mathematically, in a criminal trial, the state must prove guilt about 99%. In a civil case, the plaintiff must prove the defendant's guilt 51%. In a civil case, the law considers the playing field much more level than in a criminal case. In a criminal case, it is the state versus a citizen, and in a civil case, it is a citizen against another citizen. In a criminal case, the defendant cannot be forced to testify against himself. In a civil case, the defendant can be forced to testify whether he wants to or not. In a criminal case, the state must be very careful to ensure that the defendant receives due process of law. The guidelines the state must follow concerning searches, seizures of property, arrests, booking, court appearances, and motions are clearly defined under law and operate in a limited time frame. Civil cases have rules to follow as well, but they are not as strict or as confining for the attorneys involved in the case. There is much more room in a civil case to negotiate a settlement and keep the case out of court if at all possible. Finally, most criminal acts are also torts, but some torts are not crimes. It's possible for someone to file criminal charges against another person and then also file civil charges as well. Usually, the state gets first choice in the filing of criminal charges, and the plaintiff gets the option of civil charges if he wants. Most civil settlements involve the payment of money to the plaintiff. The filing of civil charges usually is linked to the defendant's ability to pay a settlement. Another term that you should be familiar with is a breach of contract. It can arise when a contract is not fulfilled between two people. Here's an example. Take a look at this fixed post. As you can see, the officer is sleeping on the job. This is a breach of contract. The officer is violating the security services promise to protect the property. By the way, an open post or sleeping on post is unacceptable. In the security business, it is not usually the intentional things that someone does that gets them into trouble. It's the things that were overlooked or not done at all. Most civil cases revolve around a negligent act on the part of the defendant. That means that the defendant either did something that he was not supposed to do or did not do something that he was supposed to do. According to David A. Maxwell in his book, Private Security Law, Case Studies, negligence is defined as the following: the absence of due diligence, the want of ordinary care, inadvertence, carelessness, heedlessness, inattention, thoughtlessness, oversight, the doing of a thing which a reasonably prudent person would not have done, or the failure to do a thing which a reasonably prudent person would have done in a like or similar circumstance. Simply stated, negligence involves doing something in an unreasonable way. The quickest way for a security officer to get into trouble with a claim of negligence is to violate a rule, policy, or procedure while at work. That's why knowing, understanding, and complying with the directions given in your organization's manuals are so very important. Negligence can arise when a contract is not fulfilled between two people. A formal contract is a written agreement to do something in a certain way for a specified length of time. Duties and obligations are clearly spelled out, and violations are easy to see and deal with. But a contract can also be created between two people based on a set of circumstances or a situation too. This is called an implied contract, and it can be just as binding as a written one. As a general rule in our society, there is no duty on the part of a citizen to provide protection in any form to another person or another organization unless a special relationship exists between them. Special relationship definitions are constantly being reviewed by courts all over the country. Court decisions of the recent past have established special relationships between teachers and students, innkeepers and guests, employees and employers, and landlords and renters. The trend on the part of the courts is to find that a special relationship exists and that anyone who controls a property must provide a reasonable level of security to the people they invite onto that property. That's why we, as security practitioners, have to be increasingly careful about providing an appropriate level of security at a work site. The courts have created a contract of sorts that exists between the security provider and the people who live or work in the area where the security service is performed. All of this places a special emphasis on doing what the rules and regulations require us to do. The rules and regulations are going to be presumed reasonable by the court unless the plaintiff can show them to be otherwise. Vicarious liability means that someone is indirectly responsible for the actions of someone else. It is an important concept for the modern security officer to be aware of. Basically, what it means is this: if you act in accordance with the rules and regulations of your organization and conduct yourself while on duty in a reasonable manner, the organization is going to be responsible for your actions. In other words, if someone tries to sue you because of something that happened on the job, the organization is going to be named in the suit too, and they will have to defend you. The technical name for this situation is respondeat superior. It's a legal concept that says the employer is responsible for the actions of the employee if the actions are done in the scope of the person's employment. Follow the rules and you're covered. In that situation, the organization has no choice. But as soon as you go beyond the rules and do something that you're not supposed to do, or ignore the rules entirely, then you have exceeded the scope of your employment and the company can walk away from you. When you go beyond the scope of your employment, you are no longer acting as a security officer. You're a citizen acting on your own, and you will be left on your own to face the music. This is an important thing to note here. When the law imposes a legal duty or obligation on the defendant, the jury must decide if the defendant's conduct was reasonable under the circumstances. Any time that it can be proven that a security officer fails to use reasonable care and this failure causes damages, he can be held liable for his negligence. Intentional torts are a different matter. These are things that a security officer does that are intended to bring about a certain result. Intentional torts are things that are done on purpose that can get us into trouble. Although they may seem hard to imagine, here's a listing of the kinds of intentional torts that have gotten security officers in trouble in the past. Remember, intent is really not the important issue in civil cases. The question centers around the reasonableness of your actions and the harm that was caused to someone else. Assault. That means placing someone in reasonable fear of imminent, harmful, or offensive contact. Most of the time, words alone won't do that. It takes some type of action on your part. Battery. Intentionally touching someone in a non-consensual, unprivileged way. Emergency first aid is an example of privileged touching. False imprisonment, also known as false arrest. It is the unlawful detention or confinement of the plaintiff within fixed boundaries with no intention to bring the detainee before a court. The restraint can be imposed by either physical contact or by intimidation. False arrest cases occur when a wrongful detention is conducted by someone presumed to have the legal authority to make an arrest. The plaintiff must prove that the restraint was against their will. In addition, security cannot say that the plaintiff gave consent if it was done under duress, force, or fraudulent circumstances. The court is going to try to determine if the person reasonably thought that they were not free to go. Defamation. This is a communication to a third party that injures the reputation of the plaintiff in the eyes of the community, Slander is oral defamation. Libel is written defamation. Merely suggesting that the plaintiff committed a criminal act is slander. Malicious prosecution. This happens when a security officer initiates criminal proceedings while fully aware that the plaintiff is innocent. However, keep in mind that there is no liability for reporting facts to the police. Just make sure that they are facts. Invasion of privacy. The unjustified intrusion into another person's reasonable expectation of privacy. Trespass and conversion. It is defined as the wrongful presence on an individual's property and the wrongful use or taking of an individual's property. Intentional infliction of emotional distress. Using highly aggravating words or phrases or possibly sexual harassment. This is often added to other torts such as assault, battery, or defamation. As you can see from this discussion, the potential for civil liability in the security profession is a factor that cannot be overlooked. The central theme that runs through the whole liability issue is really a simple one. Your responsibility centers around doing things in a reasonable manner. A civil suit is born when an ordinarily reasonable person does something in an unreasonable way. You have to act as a prudent person would act in similar circumstances. It's often been said that getting suits filed is easy, winning a lawsuit is a different matter. Follow the work rules as they are laid out for you by your organization. Ask questions and seek clarification about the things you're unsure about. And get clarification on the things that look like they could be interpreted either way. Follow these guidelines and you'll be able to go home at night with the knowledge that you don't have to worry about a legal action. But if it does happen and someone files a claim against you, please remember they have to prove in court by a preponderance of the evidence. They must prove that an intentional tort was committed or that negligence occurred. For negligence, they must show the following. 1, an act or a failure to act. 2, a legal duty owed to them by you. 3, a breach of that legal duty. 4, foreseeable injury to them. 5, actual injury and damages from that injury. This is a pretty tall order to fill in a courtroom when you can go in with proof that you were following the rules, following department guidelines, obeying orders, and acting within the scope of your employment as an officer. Remember, your organization's manuals are going to be viewed by the court as being reasonable per se. The plaintiff is going to have to prove that it isn't, and you are still going to be backed by the organization, no matter what the decision of the court might be. When you look at work rules and regulations realistically, they do not keep you from doing the job. Quite the opposite is true. By following the rules, you'll be freed up to do the job the right way. You can focus on your duties and not worry about being sued for what you do. Arrests. When it comes to security officers, the powers of arrest may vary greatly from one jurisdiction to another. Generally, security officers have the same arrest powers as any other citizen. In some cases, the law in a particular place might provide for security personnel to have limited arrest authority, such as officers working in a mall for the purposes of apprehending shoplifters. There exists in the law a provision for a security officer to make an arrest when called upon by a peace officer to assist them in taking someone into custody. But in that situation, the authority comes from the peace officer. It's called being covered with a cloak of authority. You have to take the responsibility on yourself to find out what the specific laws are in your jurisdiction. To understand the laws where you work, it will help to know the two basic ways that an arrest is made. An arrest on a warrant is made when a judge issues a court document commanding all peace officers having jurisdiction to take someone into custody and bring them before the court without delay. This is the preferred and legally safe way to make an arrest. An arrest on view is made when probable cause exists to believe that a crime has been committed and that the person being arrested committed the crime. Police officers have much broader authority to arrest on view than private citizens or security officers. Normally, the security officer can only make an on-view arrest for a serious crime that has been committed in their presence. In either case, the arrest takes place when the person arrested submits to the control of the person making the arrest. Probable cause is a legal term that defines the amount of proof needed to place someone under arrest for a criminal act. Normally it means that there exists those facts or circumstances that would cause an ordinary and reasonable person to believe that a crime had been or was being committed and the person being arrested committed the crime. Probable cause is a very long way from proof beyond a reasonable doubt. It's important for prosecution purposes that we clearly define the facts and the circumstances that caused us to believe that a crime was being done. We must be very specific about the conditions and the facts present at the time. You may be called upon to assist a law enforcement authority in the performance of an official act. When that happens, you are temporarily or informally deputized and, for a short period of time, will have the same authority and powers as a peace officer. Be careful.
You're welcome.
Make sure that the communication from the peace officer is clear and that they are asking you for your assistance. Don't assume. When you are assisting the officer, follow their orders carefully and understand that your authority is limited to the time it takes for that particular task to be taken care of. Once the situation is under control, you will revert back to your regular security officer status, even if it's not mentioned to you that things are done and settled. You will also need to be aware of the requirements that your organization might have with reference to this situation. At the very least, you will be required to complete a very thorough report about the incident and document everything that you did. While you're under the command and control of the peace officer, you'll have to adhere to the same due process requirements that they do when it comes to the criminal code. You cannot claim civilian status with regard to what you find during a search or the type and amount of force you use to help with an arrest. You will also have the protection of the law when it comes to using force as long as you behave in a reasonable way. This is the time when a good, solid working relationship with the local police will pay big dividends to you and your organization. If they know your training, capabilities, and limitations, the process of assistance becomes much easier and much safer. Detention happens when someone who is confronted by an authority figure is placed in circumstances where it is reasonable for them to believe that they are not free to leave. The question then becomes one of reasonability. That is dependent on the circumstances. Check the local laws again to see what they have to say about your authority to detain and the limits that are placed on it. It's also possible that work rules will give you detention authority as well. Remember the reasonability concept. It could save you a great deal of time. Most state jurisdictions make provisions for merchants to go a bit further than the average citizen when it comes to protecting their property that they offer for sale in a retail establishment. Normally, it works like this. A merchant or his agent, that would be you, can stop an individual and detain him in order to make a reasonable inquiry as to his or her possession of property offered for sale in the establishment. The merchant or his agent can stop or detain if they have probable cause to believe that the individual took property beyond the last point of payment in the store. Normally, most merchants wait until the person gets outside to firmly establish that they intended to leave without paying for the property in their possession. The inquiry must be reasonable, and normally the merchant can do the following things. 1. They can ask people to show them what's in their pockets or packages. 2. They can request identification from them. 3. They can even use minimum force to keep the person there until the police arrive. Some laws even establish intent to steal by the fact that the person walked out of the store or changed a price tag on an item while in the store. Here is another set of laws that you need to be familiar with in your jurisdiction. If the actions taken by the merchant or his agent are reasonable, the store is protected under law from claims that the person was stopped unlawfully or searched without a reason. The key, once again, is reasonability. The main thing to keep in mind with the detention of juveniles is speed. If it is your intention to turn a detained juvenile over to the police, I suggest that it be done as quickly as possible. Under our laws, juveniles enjoy a special status. They are considered children for all intents and purposes and should be treated as such by security officers. They should not be questioned unless they are in the presence of a parent or a legal guardian, and should never be left unattended for even a minute while they are under the custody and control of the organization. Be very careful when dealing with juveniles. A witness officer is always a good idea. Instructors in the concept and mechanics of the use of force know that the real challenge does not lie in teaching people when to start using force. That is usually dictated by the circumstances. The real challenge is in teaching people when to stop using force. In our profession, it's relatively simple. Here are some guidelines. You can use deadly force only to protect your life or someone else's life. You cannot use deadly force to protect property. You can use only that amount of force that is needed to stop a non-life-threatening attack. You can only use force when all other methods have failed or clearly would not be effective under the circumstances. When possible, the force you use should start with the mildest form and move up the scale as needed. Let's see a demonstration with an uncooperative young man who's been verbally threatening security officers. In the first instance, the officer's request for compliance.
Excuse me, sir. Could you have a seat here in the chair for me?
I didn't do anything.
Next, a quiet, direct request for compliance.
Sir, could you have a seat for me?
I haven't done anything wrong.
Then, a command for compliance.
Sir, sit down, please.
I haven't done anything.
Sit down.
I haven't done anything.
An order issued for compliance follows.
Sir, sit down in the chair now.
No.
Sit down.
No, I haven't done anything wrong.
Sit in the chair now.
No.
When that fails, implied force.
Sir, sit down.
No.
Sit down in the chair.
No.
Sit down in the chair
No.
now.
No.
Sit down.
No.
And finally, actual force.
Sir, sit down in the chair.
What have I done?
Sit down.
No.
Sit down in the chair.
No.
When the resistance is negated, a lower form of force should be utilized. The use of any force is a last resort, not a first option. Use of force to prevent a crime will depend on the seriousness of the crime. It had better be serious before you use force to stop it. When in doubt, back off. Excessive force lies in the eye of the beholder. If you use more force than is necessary, you will be looking at a charge of excessive force. In trying to determine how much force is too much, the judge is going to be looking at some common sense type indicators of what the situation really was. They will look at such things as how many of them and how many of you? How big were they, and how big are you? How much use of force training have you had? The other person's mental or physical condition, resources, alternatives, and options available to you, warnings given, and options and alternatives tried. Every instance of the use of force by security personnel is going to be looked at carefully by the courts and by the media. Since there is no great body of law to use as background for legal argument, the next case that shows up may be the one that goes to the Supreme Court and sets the standard for the rest of the profession. Be careful and be reasonable. Peace officers may conduct a search based upon probable cause and with emphasis on being very particular about the place to be searched and the things that can be seized. In the protection business, we have to rely on two different methods to conduct a search. First, we can conduct a search when we've been given consent to search by the person who has control of the area or property. The consent that they give us must be given knowingly and willingly. We also have to confine the search to the area for which the consent is actually given. The person can also withdraw the consent at any time. Consent can be given to us in three basic ways. As a requirement of your employment, this can be found in contracts and union agreements. As a matter of public notice, we must post signs and give people the option of not entering if they don't consent to a search. And by approval or submission, during a search, you are also limited to the kinds of items that you can seize. They consist of the following: property belonging to the organization that the possessor has no permission to have, evidence of the commission of a criminal act, and weapons and obvious contraband. You need to know that items found in plain view are not considered to be found in a search. The determining factor as to whether or not something was in plain view is this: was the security officer in a place that he or she had a legal right to be? If the answer is yes, and the item is there to be seen, then it can be seized if it meets one of the three criteria mentioned. There's no law stopping private citizens from talking to one another about anything they wish to talk about. That simple premise is the backdrop for a discussion about security officer interrogations. When we conduct an interrogation, we are questioning someone with the intent to use the information they provide. Police intend to use the information in court and to try to get a conviction. Security, on the other hand, gathers the information in order to discipline or terminate an employee. The police have to go by the Miranda rule. We have to adhere to the Weingarten rule. Under Miranda, the police must tell a suspect who is actually in custody and being interrogated that they have certain rights under the law. These rights include the right to remain silent, the right to request an attorney, and the right to stop answering questions at any time. If the suspect invokes any of these rights, the interrogation must stop immediately, and nothing obtained in violation of the Miranda rule can be used against the suspect in court. Under the Weingarten rule, employees who belong to a union are entitled to union representation during questioning by the employer or the employer's agent. Failure to honor the person's request for a union representative has been ruled coercive by the U.S. Supreme Court. The request for a union rep leaves the security officer with four basic options when conducting the interview. 1, grant the request and get a union rep in the room. 2, deny the request and stop the interview. 3, tell the employee that the company is set to take action with the facts that they have. 4, recommend action to be taken with what they have and don't even hold the interview. As with most court decisions, there will be more interpretation and more cases decided on this rule. That's our program on civil law and civil liability. Thank you for joining us, and we'll see you next time on PSTN.